Hello and welcome to the Formidi Privacy Pulse, the podcast where we decode global data privacy trends and help you stay compliant, informed, and ahead of the game. I'm Annie Garcia, Senior Legal Manager here at Formidi Data International, and today we're diving into one of the biggest changes to UK data protection law since Brexit, the Data Protection and Digital Information Bill, or DPDI Bill for short. This bill is more than a legal update. It's a fundamental shift that will reshape how organizations in the UK handle personal data, cookies, subject access requests, and much more. So, let's get straight into it. What is the DPDI Bill? The bill is the UK government's attempt to streamline data protection regulation, support digital innovation, and reduce what it sees as excessive GDPR red tape. But don't be fooled. This is no deregulation. It brings new obligations, new definitions, and new enforcement powers. Here are 3 key areas it covers. 1. Data access rights. Expanded. The bill could extend access rights beyond personal data. Think service performance data, internal process metrics, even product quality feedback. That means data subject access requests, or DSARs, could start including business information that was never previously considered. 2. Digital identity verification. We'll see a framework for digital ID, allowing people to prove who they are online more securely. Great for user convenience and fraud prevention, but it introduces new identity management responsibilities for data controllers. 3. ICO out, Information Commission in. The Information Commissioner's Office will be replaced by a new Information Commission with clearer accountability and a stronger mandate to enforce. This signals more structured and potentially stricter oversight. How will this impact UK GDPR and PECR? Let's unpack the real-world impact. 1. Fines. PECR violations, like unlawful marketing or cookie misuse, could now attract UK GDPR-level fines. This raises the stakes for every business using direct marketing, email campaigns, or website trackers. 2. Cookies. The bill proposes consent exemptions for certain cookies, like analytics cookies. This could simplify banner fatigue, but you'll need to review your cookie policies to see what still needs consent. 3. DSARs. With access rights expanding, DSAR processes must evolve. You'll need clearer policies and more agile response capabilities, especially if internal data or product metrics are requested. 4. Complaint handling. Before a complaint reaches the regulator, organizations must show they handled it internally. So, yes, you now need a data complaint process on file. 5. Legitimate interests. A new list of recognized legitimate interests, including safeguarding and national security, aims to reduce red tape. And there's more flexibility for organizational interests, reducing reliance on complex assessments in some scenarios. 6. International transfers. The bill opens the door to more flexible adequacy decisions, potentially increasing the number of countries UK businesses can transfer data to without SCCs. 7. Automated decision-making. There's more clarity around automated processing. The bill supports innovation, but ensures human oversight in high-risk decisions remains. 8. Children's data. The bill reinforces privacy by design and by default, particularly when children's data is involved. Expect continued pressure to align with the UK Children's Code. Let's look at what organizations should do next. Here's your practical checklist. 1. Review PECR compliance, especially around marketing and communications. PECR is being modernized, and fines for breaches, especially for unlawful marketing or using cookies without proper consent, will now mirror GDPR penalty levels. That's up to 17.5 million or 4% of global turnover. Here are a few important action points. Audit all marketing activity, email, SMS, cold calls, to ensure proper consent or soft opt-in mechanisms are in place. Check compliance with unsubscribed processes and do not contact lists and train marketing teams on compliant data handling under the new regime. 2. Review cookie consent procedures. The bill proposes removing the need for consent for certain low-risk cookies, such as those used for analytics or service improvement. Action points. Conduct a full cookie audit to categorize cookies based on function. Update your cookie banner and privacy policy to reflect new exemptions. Consider simplifying user consent flows where exemptions apply, but don't remove consent prematurely. This is also a good time to reassess your use of consent management platforms, CMPs. 3. Amend and strengthen DSAR policies. With the potential for access rights to extend beyond personal data, your DSAR policy must be updated to handle requests that include company or product-related data. Action points. Expand internal definitions of what constitutes disclosable data. Establish robust triage systems to assess the scope of requests early. Train your data teams to assess and redact non-disclosable or confidential business information. Ensure timelines and escalation procedures are aligned with the new expectations. 4. Implement a structured complaints procedure. The new bill places greater responsibility on organizations to deal with data protection complaints internally before individuals escalate to the Information Commission. Action points. Introduce a documented, accessible complaint procedure for data subjects. Log all complaints centrally for audit trail and accountability. Assign named roles within your DPO or compliance team to respond and resolve complaints. Include complaint response timelines in your privacy notice or transparency materials. 5. Reassess legitimate interests assessments, LIAs. With a new list of recognized legitimate interests and an expanded definition of organizational legitimate interests, the bill opens up new lawful bases for data processing. Action points. Identify processing activities that could fall under new exemptions, e.g., safeguarding, democratic engagement, crime prevention. Revisit and potentially streamline existing LIAs where appropriate. Continue to document justification and safeguards. Regulator expectations for accountability remain high. 6. Review and map international data transfers. The bill introduces a more flexible adequacy framework, meaning organizations could have more freedom to transfer data globally, but the accountability principle still applies. Action points. Conduct a full mapping of cross-border data flows. Determine if any current SCCs or IDTAs could be replaced with new adequacy mechanisms. Ensure transfer risk assessments are up to date and cover technical and organizational security. 7. Reaffirm data protection by design and default, especially for children's data. The bill reinforces the importance of building privacy into systems and services, especially those accessed by children. The UK Children's Code is still in play and carries real enforcement risk. Action points. Review digital products and platforms used by children or young people. Ensure age-appropriate design and default privacy settings. Limit profiling and data sharing for under 18s unless necessary and justifiable. Here's a bonus. Appoint or reassess your DPO or privacy lead. The governance changes, especially the replacement of the ICO with the new Information Commission, mean regulatory scrutiny will likely increase. If your DPO is overextended, not properly resourced, or non-existent, it's time to act. Action point. Consider engaging an outsourced data protection officer, DPO, like Formity, to ensure expert oversight, proactive risk management, and up-to-date compliance across all regions where you operate. These aren't hypothetical changes. They're coming. And those who prepare early will be in a far better position to adapt, avoid disruption, and build trust with customers and stakeholders alike. That wraps up Episode 5 of Formity Privacy Pulse. I'm Annie Garcia. Thank you for listening, and if your organization is navigating the complex intersection of data privacy and regulation, we are only a free consultation call away. Let's build your governance roadmap together. Until then, stay privacy smart.